Entire criminal procedure code, arrest is not defined anywhere. Yes, it is discussed thoroughly in chapter 5 of the code, but it is not defined anywhere. So how do we understand arrest? It's purely, we have to go by the definition, meaning, and the practicality attached to it. So the term arrest, it necessarily means apprehension of a person by legal authority. Apprehension of a person by legal authority. And the arrestor, that is the person who is arresting the person, obviously the liberty of the arrested person goes in control of the arrestor. I guess I'm clear. The term arrest necessarily means apprehension of a person by legal authority. And after the arrest, the liberty of the arrested person goes in the hands of the arrestor. Now, what is custody? We might think here that the term custody and arrest are synonyms, but actually it is not. In every arrest, there is custody, but in every custody, obviously there is no arrest. In every arrest, there is custody, obviously, but it is not the vice versa. Right? Now, the issue is who can make arrest? First thing, if we deal with this. Section 41 of the Criminal Procedure Code, it deals with the arrest. It deals with arrest. It says that arrest can be made by a police officer in without warrant in a case where a cognizable crime is committed or there exists sufficient suspicion or credible information about a cognizable offense is about to be committed. So section 41 of the code deals with arrest by police officers. Otherwise, arrest can be done by police officers, magistrates, even by private persons. That is another chapter, but since we are concentrating on police custody over here, let us talk about the arrest by police. So section 41 deals with the arrest by the police personnel. When the police personnel can arrest without warrant, when there is a cognizable crime has been committed or there is a reasonable suspicion or a credible information exists that a cognizable crime is to be committed by a person, then only the police can arrest without warrant. And with warrant, the police can arrest for only when a warrant is issued by a competent authority, or say by a magistrate or by any competent authority, competent judicial authority. Now, section 72 to section 74 of the CRPC, or the Criminal Procedure Code, and in short CRPC, it deals with arrest. It deals with arrest under a warrant. Now, the arrest is done. What is to be immediately done? Once the arrest is done, accused who is arrested, or the arrested person has to be brought before the nearest magistrate having sufficient jurisdiction within 24 hours of such arrest. So once a person is arrested, that person has to be brought before the nearest judicial magistrate having competent authority to deal with the offense within 24 hours of that arrest. The time of journey from the arrested place to the magistrate is excluded in this case. So suppose if somebody gets arrested in Howrah and is brought, say, 20 kilometers down to Barashat for his production, then that intermittent 1 hour or the time which will be taken for the travel, that will be excluded from that 24 hours. But to have a gross idea of this, a person arrested has to be brought before the magistrate within 24 hours of the arrest, and the time taken for such travel to the magistrate has to be excluded. Now the next part is, when the arrest is being done and the police officials bring that person before the magistrate, what happens then? There are two options to the which are open to the magistrate. Either the magistrate will grant that person a bail, or he will reject his plea of bail and will remand him to police custody or judicial custody. Now, bail, as a matter of fact, bail is a matter of right in case of bailable offences. But in non-bailable offences, It is up to the magistrate. It is purely on the discretion of the magistrate whether that magistrate will grant bail to that particular person or not. So in case of non-bailable offences, there are high chances that the person who is brought before the magistrate under arrest shall be remanded either to police custody or to judicial custody. Now the question remains, when should a person be sent to judicial custody and when should a person be sent to police custody? Now this again depends on the uh, discretion of the magistrate, and it depends on a case-to-case basis on what materials there are for remanding a person to police custody, or whether at all the police, while bringing that person to the, while bringing the arrested person in front of the magistrate, at all wants his police custody or not. But if the police wants a police custody, then in most cases, not in all cases, but in most cases, the police gets a custody of that accused person by an order of the magistrate. Now, this police custody can be for a maximum period of 15 days, starting from the date of arrest. So it has to be within a period of 15 days. Okay. And now this 15 days has to be the initial 15 days. So suppose a person is brought before the magistrate on the 10th of a month, then uh, the police can have custody of that person, or the magistrate can grant police custody of the accused person till 24th of that month. It might happen that such police custody will be granted at different times, at different intervals. Meaning, say on a person is brought before the magistrate on 10th, the magistrate grants him a police custody for say around say till 17th. Now the police comes up again to the magistrate on the 17th, bringing the accused in front of him and says, okay, we have not been able to gather all the information which we required, so we need further police custody of this accused person. Then the magistrate can again grant him a police custody. But that custody has to be within 24th, starting from 10th. So it has to be within a period of 15 days and the initial 15 days. So this is the entire issue regarding the regarding arrest and police custody. After 15 days, however, whatsoever be the crime, it might be a very heinous offense, it might be a very it might be a sessions tribal offense like say a murder or an attempt to murder or a rape or a dacoity. But even after that, the police cannot have the police cannot have custody of a accused person or a arrested person more than 15 days. Yes, that person can go to judicial custody after that, but no police custody for more than 15 days. Now, regarding this police custody, but these are what are on these are things which are being guided by the books, by the criminal procedure code. Now there's another story attached to it, because in India there are instances, we are all aware of it, that there are instances of police excesses. Police excesses in the sense, uh, the torture by the police while the accused person is in custody. These things are very common in India. So thankfully, the high courts of the different high courts and also the Supreme Court has come forward on this issue, and they have framed some guidelines. Though it's unfortunate that till date the government has not yet framed such guidelines, or in the code it is not specifically mentioned what are the rights of the accused person and not. Yes, it is mentioned in the obviously it is mentioned in the Constitution, but it's not mentioned in the code. But the Supreme Court and the different high courts have come forward and formulated some guidelines. I will come to that later. Uh, I was talking about police excesses. This police excesses, firstly, though we don't have sufficient information, we don't have uh, full information and credible information regarding the actual police excesses which have been practiced in India. Say we in rural areas, at least in rural areas, we don't have enough information about the police excesses that have been practiced. Those are not brought on books. Those are not being reported. In urban areas, we have a general knowledge over that, because there is a tendency of things being getting reported in the urban areas as compared to the rural areas. But in the rural areas, we don't have any information. We don't have a credible information over this. But as far as the government figure goes, in 2017 alone, there was more than 100 custodial deaths. 100 custodial deaths. Back in the 90s, it was somewhere around 140 to 150 per year. 2018, 2019, we don't have the figures right now. At least I don't have the figures right now. But in 2017, it was 100 custodial deaths in 2017 alone, leave alone the other police excesses. Uh, Now, this is custodial death. 100 custodial deaths, that doesn't mean the entire death has happened within the police prison, within the police station, or in police custody. Jail custody or judicial custody, as it is commonly known, is also included in this. The 2017 figure, I can give you the 2017 figure. It's around 50-50, somewhere around 50-52 deaths in police custody and 48-49 deaths in judicial custody. So this is the figure. Now, if we come to the rights of the accused person, as I told you that the Supreme Court and the different high courts have come forward to frame guidelines over this. But before that, the Constitution of India, if we read Section 21, Article 21 and Article 22 of the Constitution, we can have a knowledge over what is the right of the constitutional right of the accused. Article 21, we are all aware of Article 21. I'm just reading out Article 22 for you. No person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. And second, 22, this is Article 22, Clause 1, and this is Article 22.2, which says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of such arrest to the court of the magistrate. And no person shall be detained in custody beyond the said period without the authority of the magistrate. So Section 21, Article 21, we all know that no person shall be deprived of his life or personal liberty except according to procedures adopted by law or established by law. This is Article 21. Article 22, the second part of Article 22, I was talking about that is also provided in the code, that a person who is arrested has to be brought before the magistrate within 24 hours, the time of journey excluded, and no person shall be detained before beyond that period of 24 hours. Now, what does Article 22.1 say? Article 22.1 of the Constitution says that a person who is detained in custody, this has been further detailed in different Supreme Court judgments, which I will come to later. Article 22.1 of the Constitution thus says that no person who is being arrested shall be detained in custody without being informed as to why he has been taken into custody, or he shall not be denied the right to have right of having consult a legal practitioner or to be defended by a legal practitioner. So if a person is arrested, he is brought under arrest before the police station, he has every right to be defended by a legal practitioner of his choice, his or her choice. And that this choice is mandatory. This choice is governed by the Constitution of India. This choice is further established by the guidelines which have been made by different high courts and the Supreme Court of India. Now, The Constitution of India was formulated way back 70 years back. But even after that, there was random police excesses throughout pan India. There were random police excesses, custodial deaths, tortures, otherwise tortures in the police station, even at some point custodial rapes also. Uh, so uh, then the matter was brought on different occasions before the Honorable High Courts and the Supreme Courts. The Honorable Allahabad High Court, uh, in course of investigation, the Honorable Allahabad High Court, this was reported in 2002 CRLJ page 2907. I'm repeating, this was reported in 2002 CRLJ page 2907 in Gulab Chand Upadhyay versus State of UP. Gulab Chand Upadhyay versus State of UP 2002 CRLJ, that is Criminal Law Journal, page 2907, which says here the Allahabad High Court, this is a very important judgment. Here the Allahabad High Court said that arrest is no doubt a part of the investigation, but the magistrate can place restriction on the power of arrest by the police. It obviously upholds, this judgment obviously upholds that arrest is a very important part, an integral part of investigation. But yes, it gives the right to the magistrate to exercise his discretion to place restriction upon the power of arrest of the police. So arrest of a person does not ever mean that the police can do anything with that person. The Supreme Court in CBI versus Anupam J. Kulkarni, CBI Central Bureau of Investigation versus Anupam J. Kulkarni. This was on 8th of May 1992, and it is reported in AIR 1992, page 1768. AIR 1992, page 1768. This has been reported here by. This is a judgment of the Honorable Supreme Court in CBI versus Anupam J. Kulkarni, where the Supreme Court further confirmed that the police custody can be granted for a maximum period of 15 days, but on different times, but within the first 15 days of arrest. So again, within the first 15 days of arrest, a police custody can be granted for a maximum period of 15 days on different times. It can be, but it has to be within the first 15 days of arrest. Now, this is in case of a judicial magistrate. If a person is arrested and is brought before an executive magistrate, this part has also been dealt in this judgment of the Supreme Court. If a person is brought before the executive magistrate on arrest, then the executive magistrate can send him to police remand for a maximum period of 7 days. And after which that person has to be sent to a judicial magistrate having competent jurisdiction of it. Next is the most important judgment, and there are several guidelines over it, which I will have to read out because there are 11 or 12 guidelines, which is of paramount importance here. This is a mother judgment, as we call popularly in our legal circle. This is the judgment which is being reported in AIR 1997, Supreme Court 610. AIR 1997, page 610, judgment of the Supreme Court. This is a judgment of D.K. Basu versus State. Here, the matter of police excesses were taken up by a bench of most probably five judges of the Supreme Court, and after senior judge of the senior advocate of the Supreme Court was he was appointed as an amicus curiae to help the court over this, to assist the court over this, and beyond that, different opinions were sought from the different states of India. So after having the opinions and the records of all the states of India, the Supreme Court came to a decision and formulated a certain guideline. Till any such guideline is being formulated by the government and is brought in the code or in the constitution, the Supreme Court made some guidelines. Now, what there were 11 or 12 guidelines, 11 guidelines to be specific. Number one, the police personnel who will be carrying the arrest and handling the interrogation of the arrestee must have a visible tag of identification with their designation. And the particulars of the police official who is handling such interrogation of the arrestee must be recorded in a register. So firstly, when a police goes and arrests someone, this is in the Supreme Court guidelines, I'm just clarifying it. When a police personnel goes and is arresting someone, then that police officer must have a proper identification badge which is visible to the arrested person. And that person, and while interrogating that person, the entire particulars of the police personnel who is conducting such interrogation has to be recorded in the police register. And we got it because there are two parts of police custody. One is when the accused is not placed before the magistrate, and when the accused is placed after the accused is placed before the magistrate. In the first 24 hours, the accused is not obviously placed before the magistrate. So here also this rule applies, and even if the police gets a police custody after being authorized by the magistrate, then also these rules apply. So this is the first one. The second one says that the police officer who is making such arrest shall prepare a memo of arrest at the time when the person is arrested. And that memo of arrest, it is a memorandum. There is a prescribed form of that memorandum. So the police officer who is carrying out that arrest shall prepare a memo of arrest while making such arrest, and that memo of arrest has to be signed by a member of the family of the accused or any respectable member of the society or rather the locality from where the arrest is made. It needs to be countersigned by the arrestee and shall contain the date and time. So when a person is arrested, the police official performing such arrest, he has to prepare a memo of arrest. In that particular memo of arrest, the details of the arrested person has to be filled up. It has to be signed by a member of the family or by any person of the locality from where that particular accused is arrested, and it shall contain all the particulars including the date and time. Why the date and time is important over here, and why I'm specifying on the date and time? Because of that part of 24 hours which needs to be calculated. Third is when this is regarding that Article 22(2) of the Constitution. The person who has been arrested or detained and is being held in custody in a police station or interrogation center or other lockup shall be entitled to have one friend or relative known to him or having interest in his welfare being informed as soon as he is arrested, as soon as it is practicable, rather, that he has been arrested and is being detained in that particular place, unless that attesting witness of the memo of arrest is himself a friend or relative of the arrestee. So it means that when a person is arrested and is being detained in the police custody, it is the duty of the police personnel to inform the relative of the person who is being arrested that this person has been arrested and apparently for this crime, unless that particular witness, that particular relative is a witness in the memo of arrest itself. The next one says that the time, place, and venue of the place of arrest, and the venue of custody of an arrestee must be notified by the police where the next friend or the relative of the arrestee lives outside the district or town through legal aid organization and to the police station of the area by telegraphic means within a period of 8 to 12 hours. So it might happen that a person who is residing in Calcutta is arrested from Mumbai, and he has nobody over there, no relative or friend over there. So what is the duty of the police officer then? The duty of the police officer is then to inform about the arrest within 8 to 12 hours of that arrest to the nearest relative or friend of that particular person who is being arrested. and this has to be done. Today there are many methods. This has to be done telegraphically. Remember the meaning. It has to be done within a period of 8 to 12 hours. It can be done through legal aid organizations. It can be done through another police station where the next friend or the relative resides. But it has to be done within a period of 8 to 12 hours. And the next guideline says that the person who is being arrested, he shall be informed that his friend or relative has been informed about this matter. This one shall he has to be made aware of this. That yes, we have informed your friend or your relative about your arrest. Next comes the place of detention. An entry must be made in the diary at the place of detention regarding the arrest of the person, which shall disclose the name of the next friend of the person who has been informed on the arrest, and the names and particulars of the police officials in whose custody the arrestee is. So again, the question of registrar comes. Entry must be made in the police diary. There is a diary in the police station, as you all of you know, I guess. So there is a diary in the police station. So there has to be a GD entry, a general diary entry in the police station, stating the detention of the arrestee, stating the place of detention, stating the particulars of the arrestee, and stating the police official, stating the particulars of the arrestee, stating the particulars of the next friend of the arrestee, and also stating the particulars of the police official who is interrogating that particular person. Next comes that the arrestee, where he or she requests, can be examined medically at the time of his arrest or any time after that for any major or minor injuries if present in the body, or if he or she thinks that he or she needs to be examined by a doctor. So if the arrestee requires, if the person who is arrested feels that he or she needs to be examined for any minor or major injuries by any doctor, that has to be done. And the inspection memo must be signed by both the arrestee and the police official affecting the arrest. Now, this was regarding the major and minor injuries. Now, this is the next guideline. This guideline is a compulsory thing. The arrestee should be subjected to medical examination by trained doctor every 48 hours during his detention by a doctor on the panel of the approved doctors of the government. Now, this is a mandatory provision that the person who is being arrested, that person has to be subjected to medical examination, even if he or she doesn't ask for. Every 48 hours during his detention by a doctor who is on the state government panel. Copies of all the documents, the memo of arrest and all the other documents, this inspection memo that this person has been medically treated time and again, all these documents needs to be placed, with copies of all these documents needs to be placed before the concerned magistrate when he along with the accused. So when the accused is placed before the concerned magistrate, all these documents needs to be placed also. The arrestee must be permitted to meet his lawyer. This is another guideline. During interrogation, though not throughout the interrogation, but he can always seek for legal help. And the last one is a police control room that should be provided at all districts and state headquarters, where information regarding the arrest and place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest. And at the police control room, it shall be displayed on a conspicuous notice board. So this is not practiced widely, but the provision is there that a police control room should be provided with all the details of all the arrestees, and the police control room shall, in a conspicuous place, that is a place which can be seen properly, the police control room should be displaying on a conspicuous notice board the details of such arrest. So I think the matter we need to sum up here now. It's 5:20 already. We need to sum up here. So I guess everybody is aware of the part of arrest. What is the meaning of arrest? what is the meaning of police custody, and what happens in police custody, what is supposed to happen in police custody, and what happens in actual in police custody. I guess we are left with only one part, that is police custody during this COVID times. Yeah, these are very testing times for everybody. These are very testing times, not only for, especially for the persons who are being arrested or are in custody, be it in police custody or if they in judicial or jail custody. Because for obvious reasons, we know that there are health hazards involved, and the health guidelines which have been provided by the government, or otherwise which are in our common senses actually also, that are not being maintained properly. Hygiene is not being maintained. Hygiene is not a thing which have been maintained in the custodies, be it in jail custody, be it in police custody. So it's a matter of great concern here, because people are cramped in very dingy rooms, very dirty rooms, which can which cannot properly say a police lockup can hold how many, say 10 persons at the max. There are occasions when 12, 15, 20, 30 persons have been put there. So this is an area of great concern, but I don't think if people can take up this issue and fight over it, then it's good, because at least to my knowledge, nobody is fighting over this right of the accused persons or the arrested persons, the persons who are in custody right now. Everybody is bothered with themselves, their own health hazards and all. So nobody is quite bothered about this part, at least as far as my knowledge goes. But this is an area of grave concern, because the risk of getting affected is very high. But one thing, and yes, there is a lack of legal representation also. During this COVID times, there is a lack of legal representation also, because for obvious reasons, lawyers are not always available. The court is not functioning as it should, as it a normal functioning of the court is obviously hampered, as you all know. Yes, the bail file, as we say, that is, if a person is arrested, the bail matters are being heard, but well, again, there is a lack of representation, lack of proper representation, and so that's harming everybody. But yes, generally we have seen a trend over this during the COVID issues, that during the COVID times, that generally the courts are inclined to grant bail if there is a 50-50 situation. Generally, I won't say all courts, but generally the courts have a tendency now to grant bail during these COVID times. There is no uh, dictum regarding this from the Supreme Court or the High Court. There is no guidelines also regarding this. But as if we talk of tendency, we can say yes, it's a bit more than in normal times. But that doesn't take away the problem, because for obvious reasons, there are so many people are languishing behind the bars right now, and there is a great, huge risk, huge health risk of health hazards now. And today or tomorrow, those persons will come out. We don't even know if they are whether they are properly being tested for COVID or not. As far as my knowledge goes, COVID tests are not being done with the prisoners, or with the persons who are in police custody. So today or tomorrow, these persons will be out on bail. So the spread can happen from there also. So this is it. These are testing times. I guess I'm done with it. And any questions, I'm open to it.
Thank you for the session, sir.